Right. And I know it's awkward to ask your parents about their money. I know it's awkward. I get that. But if you get your own estate plan done, it empowers you to have conversations with other people to say, when you get your estate plan done, you have to make sure that all of your assets match your plan. And the word of art that we use in my line of work is funding. We make sure the funding is completed, and then your estate plan is actually complete.
Did you plan for this, or did you miss when life demands answers you can't dismiss? Will you be ready when the trumpet blows? Do you have the blueprint for life's unknowns?
Ron, we hear about celebrities all the time, and we forget sometimes that they're just people like us. And sometimes going to court is the only way to resolve certain issues. And there's a particular celebrity who's really near and dear to my heart because, oh my gosh, watching old tapes of his headline jokes, still make me crack up so hard. And his name is Jay Leno. Jay Leno, the renowned comedian and former host of The Tonight Show, has been navigating a deeply personal journey as his wife, Mavis Leno, battles dementia. The couple, married since 1980, has faced this challenge with resilience and mutual support. And I just want to point out that if they didn't have to go to court, we really wouldn't know about this. And that's just such a thing about being a celebrity, right? That people are interested. We're always so curious. And stay curious through this one, because I think we have a lot to learn together. So here's some details. The petition was filed. In January 2024, Jay Leno petitioned the Los Angeles Superior Court to be appointed as the conservator for his wife Mavis's estate due to her dementia diagnosis, which impaired her memory and cognitive functions. He got court approval. The court granted the conservatorship on April 9th, 2024. I just want you to note the distance of time between January and April, okay? During the hearing, Mavis's attorney stated she was in agreement with the conservatorship and noted she was receiving excellent care from her husband. The judge acknowledged that Mavis was in the least restrictive environment and under very good care with Jay Leno. So isn't that fascinating that there'd be some judgment from a third party, in public, that his own wife is receiving good care from her husband?
Plus you also, and we'll talk about it in depth, Mavis's attorney.
Yes.
Does she have the capacity to hire an attorney? So we can talk about that after you finish. But that's I think that's going to hit home with a lot of viewers and listeners.
Sure. In a conservatorship proceeding, and let's just be clear about what conservatorship is. So we've talked about probate before on this show, and probate court is the court that is in charge of all of these transitions, these transfers, right? For instance, a probate procedure or a probate court hearing might be about transferring the assets of a dead person to living relatives of that person because the dead person died intestate, meaning they didn't have a plan, or they might have had a plan that didn't work exactly, or the people that were supposed to receive it had died. So there's lots of good reasons for having to go to probate court to get things sorted out. It's a blessing in that regard. But there's something else that the court does, and this doesn't happen in adoption court or in family law court or anywhere else. And that is that the probate court also handles conservatorship. So in the rest of the country, this is referred to as guardianship. That means that someone else is being the guardian or conservator of the person or of the estate. In California, we have it as two separate jobs. You can be conservator, meaning that you are protecting the assets of and the person of, conservator of the person, or you can be conservator of the estate. That means you're handling the money and the transactions and so on. So the way I read this is that Jay had to petition the court to get permission to be in charge of his wife's finances. Isn't that interesting? Independent Trustee Alliance is a proud nonprofit sponsor of Plan for This. If you are considering serving as a trustee, please visit trusteealliance.com to learn more about this complex and sometimes overwhelming job. trusteealliance.com. Plan for this thanks the Estate Sale Warehouse for all their amazing service and support. Entire home cleanouts, inventory, appraisal, auctions, sale of fine art and classic cars. Learn more at estatesalewarehouse.com.
Why do you think that would be?
Well, either there were new decisions that need to be made that Mavis wasn't capable of participating in. I also suspect that there were some events that occurred for Jay. So it's not in this particular story, but I'm aware of the year before he had to go to court, Jay had two very big health emergencies of his own. He was working in his own garage. Everybody knows he's a car guy. He's very loved in the community and so on, but he had a gasoline fire that burned his face in his own garage.
Correct.
We don't know if Mavis was able to assist him in that emergency. Jay recovered from that particular accident, but not much longer after that, he ended up in a motorcycle accident where he broke his leg. And, those kinds of events can just be survived and you just get through it. But if you're also taking care of someone who has dementia and you can't get up out of bed now because you have a broken leg, that's a real problem.
So you think that's what prompted it? I mean, we don't know exactly, but it prompted to go to court as opposed to making it a public display, so to speak, rather than a private concern.
So let's talk about capacity for a moment and what that means, because that really plays into what we're talking about here. So if your life partner no longer has capacity, that means that really it's unethical to make them sign something they don't understand what they're signing. I mean, that's pretty obvious, right? And you can't just forge their signature. I mean, each one of us is sovereign. Each one of us matters. So legally, we have a position to take and our own interest to protect. So if someone lacks capacity, meaning they don't understand the consequences or they don't understand the language, there's no way for them to comprehend what this means, then somebody has to be in charge of that person. And that's what conservatorship is about. We realize someone is really uncooperative or really vulnerable and they're out in the world and they need to be protected maybe from themselves.
So Jay would have to bring to court the situations that prove beyond a shadow of a doubt, so to speak, that Mavis is not capable of running her own life.
It's very likely in unusual conservatorship proceedings that there are doctor's letters that state that this person's no longer able to manage their own affairs. Now, if there's a trust, and not only is it a trust, so let's talk a little bit about what is in an estate plan. An estate plan consists of several documents. We're going to do this for a couple, and we're going to do this for Jay and Mavis, okay? Jay and Mavis own the house they live in. Jay obviously had a very vibrant career. He may still be getting residuals and payments from shows and so on that he did in the past. He still continues his car collection. He may have other things. It's possible that he and Mavis own the cars together, but he's just the one who works on them. So those kinds of things need to be figured out and laid out in terms of the trust. What happens to Mavis if something happens to Jay? What happens to Jay if something happens to Mavis is part of the estate planning mix, but the trust is just that first document. And they're both trustors, creators, settlors, grantors of the trust, and they may have both been the trustees of the trust. And I've said this before, I'll say it another 100 times.
O-R and E-E.
Right? Trustor, employer, trustee, employee. Right? So we understand the roles.
Write that down. No, because that is again, we don't do this every day in our lives. It's just like anything else. Like when people that buy a home, you don't do it every day. We don't expect you to understand every document. This is so important though, because when you, like you say, when you become a plan fan and you're able to, and you're a subscriber and you can go get the details and these checklists that take to your attorney to understand these terms. So when the attorney brings you into his or her world, you are on the same playing field.
Right. Right. I mean, that's what we really want for everyone is everyone has an estate plan and then it becomes normal in our language, right?
Correct.
But we only still have a third of American adults with any kind of plan. So in terms of the estate plan documents, we started with the trust, and we've kind of explained a little bit about that. And the trust becomes like an operating agreement. So anybody who's ever had a business, or if you've been part of a partnership or anything, you know there's such a thing as an operating agreement. And often the top of the trust is going to say trust agreement. Well, who are you making the agreement with? Yourself.
Yourself.
Right? But you're also committing as trustee of your own trust to do certain things to make sure that this document works. As an example, your house has to change title and be titled in the name of the trust for the trust to be the operating agreement on that asset. So the trust can only deal with the assets that are titled in the name of the trust. And in the name of the trust could be the owner. The trust can be the owner of an asset, like my trust owns the shares of my company, but also it could be the beneficiary. My trust can be the beneficiary on a life insurance policy so that the instructions of my trust are followed when that death benefit gets paid. So that's part of arranging this in your mind as a business choice. How is the business of my life going to be handled? I'm creating an operating agreement by having a trust.
So just before you go on to the next document, I will give this advice to everybody listening or viewing. If you have done a refinance over the last few years, if you've had a divorce over the last few, if you've done anything to change your entity, there's very likely that if you had a trust, that's only a third of the country, only a third.
Right.
You had it in a trust. It could very well not have been properly put back, entitling. You don't obviously physically put the home in the trust doc, but the titling is back in the name of the Mary and Joe Smith Family Living Trust. That is what you need to make sure you're following up on.
Oh, I can hear somebody in the audience saying, but I have a binder with my trust and I have a list of my assets and it's in the binder. It's in my trust. No. Having a list of assets is not the same thing as changing the title on those assets to match your trust.
Right. That is a big miss from a lot of people who think that everything is fine. But then if something happens, the heirs or the trustees, the successor trustees are in a world of hurt.
Right. And I know it's awkward to ask your parents about their money. I know it's awkward. I get that. But if you get your own estate plan done, it empowers you to have conversations with other people to say, when you get your estate plan done, you have to make sure that all of your assets match your plan. And the word of art that we use in my line of work is funding. We make sure the funding is completed, and then your estate plan is actually complete.
So write that down. When you're subscribed to Plan for This and you get our checklist, you're going to see those words, funding, and that's something you're going to ask the estate planning attorney. Attorney, are you taking in charge of this process of getting the title changed from the Mary Smith to the Mary Smith Living Trust, or is it my responsibility as your client to do that?
And pretty typically, the attorney will help you with your house, but you have to do all your other assets, and you can ask for instructions and so on. And lots of attorneys will give you written instructions on to follow, but I'm just giving you the concept right now. So we're back to Jay and Mavis. Jay and Mavis now have a trust, but each Jay and Mavis will have their own following documents. Each one will have their own will. The will only operates after your death. The trust operates both while you're alive and after you pass away. But the will only operates at your death. And the will is the one document in your estate plan that becomes public after you die. It gets lodged with the county in which you live. And so your will, typically when it's done in context of the whole estate plan, is minimal. It has just enough information. It might refer to the fact you have a trust. And so it works, and it's called a pour over will. It means you pour over everything you own into the will. It's all part of that context. The other two documents are the power of attorney for finance and the advanced healthcare directive. Durable power of attorney for finance means you're granting authority to another person to deal with those personal assets, those assets that are personal to you. Individual retirement account cannot be owned by your trust. You might put in special language in your trust that deals with it, and maybe your trust can be a beneficiary, but that's for you to discuss with your attorney. But most things that you have that are personal to you, Maybe the title on your car is just in your name. Maybe you have a Medicare, Medi-Cal, Medicaid. Maybe you have a Social Security payment, a pension check. Those kinds of things are all handled during your lifetime by your power of attorney agent. Sometimes they're called attorney in fact, sometimes they're called agent. Do husbands and wives name each other as the agent? Possibly, maybe not. And so it's one of those things to look at in terms of how will your plan work when the time comes and you're not able. And I'll talk about when these documents become active.
It just the power of attorney for financial decision making, or
right, or asset management. It has lots of names.
And lots of names. That doesn't allow you to sell a house.
Only if the house is named in your name individually. And you might need your power of attorney to assist the trustee, and sometimes they're the same human, but you might need your power of attorney to assist to get that asset titled into the name of the trust if you weren't able to do it during your lifetime. So understand these are different tools in the same toolbox for the same human. So Jay now has a trust he shares with Mavis, and he has his own durable power of attorney for finance. Well, now with what we know about Mavis, can she be his agent? No. We know that, right? Because clearly she's lost capacity. She's under conservatorship. That means to me that Jay has to go and get that document updated and pick somebody else to be his agent if he loses capacity. And we'll talk a little bit about when the documents come to life. Last document for now, the Advanced Healthcare Directive. In that, you're giving someone the power, if you cannot answer your own questions, you don't understand the consequences of a procedure, you're giving permission to the medical community to talk to your agent, the person you pick to be your spokesperson. That person should know something about you. Well, Mavis may not have been able to sign a power of attorney or a healthcare directive with Jay as her person, and that's why he had to go to court and get a conservatorship done. Now, and going forward, he may have to present to the court the new estate plan for Mavis's benefit. And maybe she won't have to be under conservatorship because, oh, look, he's now acting as her power of attorney and as her agent. I can't really speak too much to that. Again, I'm not giving any legal advice, but it's one of the questions on my mind. Because conservatorship means not only is Jay in charge of whatever happens to Mavis, but it also means he has to keep reporting to the court.
And what I was going to say, what is his ongoing role as a conservator?
Typically for conservators in California, they have to go back to the court with an accounting. So they have to prove up and show how much did this conservatee start with? So what was Mavis's assets when this started? Then he has to show what assets were spent for her care and prove up that it was really in her best interest that these funds were spent. He might even be compensated, even though that seems silly. He's the spouse, right? He probably has more money than she does, technically speaking, but that's also part of the conservatorship arrangement. He has to be represented by an attorney. Mavis has to be represented by an attorney.
Which is court appointed?
Probably, because if she didn't have capacity to actually sign a fee agreement with an attorney, to sign an engagement letter, then she might have gotten a guardian ad litem. That would be an attorney appointed by the court, who, by the way, also gets compensated by Mavis's estate, to look in on her, to drop by and visit, to get to know her. You know, dementia is not 100% kind of thing. You might be okay first thing in the morning with your cup of coffee at your house in familiar surroundings and have a general understanding of what's going on. You might even read the paper. You might even have an idea of who the president is or what day of the week it is and so on. For that moment, you're oriented to time and place.
By the afternoon,
things could change, right? Maybe Mavis can no longer drive a car, but she knows what her favorite foods are. And so part of the kindness, part of the consideration when you're a conservator for another person is that that person still needs to live their life on their terms. But now you're protecting them maybe from the outside world, or they're never going to sign another check, or they're never going to decide on another payment. They're never going to renegotiate with the cable company that they got double charged for something. Okay. So all those little jobs now all become Jay's job as her conservator.
And you can see where this could go. The the Leno story, obviously, we assume there's plenty of funds. It's a husband and wife. But just think about if there are multiple siblings and there's limited funds and somebody's trying to be the conservator for their mother or father, and there are siblings battling the sibling as to what to spend on behalf of the conservatee. It's a lot of legal action.
Well, can you imagine, Ron, that someone you love is going to go to court and petition the court to put you under conservatorship? And let me tell you, there's plenty of people that are prospective conservatees who don't want to be under conservatorship. It's a very public, potentially humiliating thing. And I don't want to see anybody have to ever resort to going to the court to figure out who's going to manage now. If they had a complete estate plan, if Mavis had signed power of attorney and advanced healthcare directive, if she had everything in order, then Jay could have just done this quietly for her. He would get a couple of doctor's letters, because generally most documents will say 2 physicians write a letter that say you're no longer capable of managing your own affairs. And then your person can take those 2 doctor's letters and go to your financial advice firm, go to your bank, go update the title, go do things on your behalf because you've granted authority and you gave them the job.
So the best that I'm surmising from what you're saying is that there wasn't an advanced healthcare directive, one of the documents that you just talked about, in place adequate enough or not in place at all to do what had to be done to protect Mavis.
Right. And so here's a very wealthy couple, well known in their community, and they had to go to court, meaning Mavis had to physically be in court so the judge could see for himself she can't manage. And honestly, personally, I would never want to put my husband through that. I think he would be super humiliated and unhappy about being publicly displayed as somebody who can't manage.
So the way to avoid that is to summarize the documents that you just talked about.
Right. And if you're looking for backup and you want more information about those particular documents, we'll have general descriptions. There is no replacement for having an attorney who gets to know you and your situation, who's local to you, who works in the jurisdiction in which you live. And that's a very important distinction. You might have a family member who's willing to throw together an estate plan for you. And maybe you don't want to spend the money on getting this done. But the advocacy is part of what we're talking about in this conversation. Why does Mavis need to be represented? It's her husband who's asking for a conservatorship, not some stranger, right? Well, it's because we're each treated as an individual citizen with our own rights. And by the way, people that are under conservatorship, and I've referred to the term conservatee, don't necessarily have the right to vote. They don't have the right to marry. They don't have the right to enter into new contracts. They can't get licensed for a profession and so on. I mean, there's a list of rights you give up as a conservatee. And by the way, the rules are different in different states. Okay. Again, it's called guardianship in other places.
There's a National Guardian Association.
Yes, the National Guardianship Association. And there are people that get certified as guardians. It's kind of a different line of work than being a professional trustee. So as a trustee, I'm able to keep things very private. I only go to court if it's absolutely necessary. And my goal in any case under which I'm serving as trustee is to stay out of court and make sure that everything gets done right. And how do I do that? Well, I have certain duties that I have to perform, that I must fulfill. And that might be keeping all the beneficiaries informed, and so there are ways that we protect the very people that we're serving by keeping their people reasonably informed. Again, if they have, they're listed in the documents and so on. There's a bunch of hoops to jump through. But there are guardians. This is what they do. They're interacting with the court all the time. They know how to do the accountings. Like Jay is going to have to produce an accounting. And I don't know if it'll be every year or every other year, but he's not done with court. Being granted the conservatorship just means he's now Mavis's person, but as Mavis's person, he has to report to the court in terms of the work he's done.
As a son who felt that I needed to go to court to conserve a parent, but I don't want that role, then that would be when I would call either a professional fiduciary here in California or a National Guardian Association to find out somebody who would take on that responsibility. It's similar to that kind of.
You could even contact the Independent Trustee Alliance, and you find them at trusteealliance.com. There are people that specialize in this work. There are people that serve as trustees and also occasionally serve as guardians or conservators. So it does take some exploration in terms of who's the right fit. If you have siblings, Ron, and also if you're in a blended family and your parent is the one who needs conservatorship, you might not want your step parent being the conservator. There's a lot of people that might have a say, and you could object to someone being conserved. Well, he was fine 3 weeks ago. What happened since then? Why do you think he should be under conservatorship? There's a lot here, and we don't want anyone to lose their rights. We don't want anyone to lose control. If you want to maintain control, you've got to get your own estate plan done.
Does it change if the Jay and Mavis situation was they were not married, or is that similar to a son, father, or daughter, mother situation?
So marriage comes with a lot of assumptions, okay? And just because you're married to someone doesn't mean that person has a right to your personal bank account. I love my husband. I trust him. We are good friends. He's everything to me. But I have some accounts he would never have access to. Why? Well, because I set those aside for my children in the future. And when we got married, we had those conversations about who gets what, how does it work, how does our life together work? So we have some assets in common with each other. That's part of the community, right? Community property, right? We have shared assets. And we have some assets that are separate and individual to us. So his sons will inherit some of that stuff. My sons will inherit some of my stuff. And all 6 of our boys are going to inherit from both of us. So it's a little more complex. It takes a little more work, a little more conversation. But I would tell you that I would object to a conservatorship because I don't want everyone to know my business. Nobody wants that. Nobody would voluntarily want to be under conservatorship. But if I was that vulnerable, it's because I didn't take care of myself and I didn't get the documents done. So I get it. A lot of people avoid estate planning because, one, they think, oh, that's for other people. That's for people with money. No, if you have a body, you need a plan.
For this very reason of you do not want to go into court, literally dragged unwillingly into court to see if you are capable of handling your own affairs.
Now, we heard from Mavis's attorney that she agreed with the conservatorship, okay? And we appreciate that she's represented, but that attorney has to be paid. Jay's attorney has to be paid. There might still be another attorney involved, the guardian ad litem I mentioned earlier. That attorney needs to be paid.
Give me that again. That's a third party?
Well, we don't know what's going on. The judge is not going to leave his or her bench to go visit Mavis at home. So what happens? Well, there might be a probate referee that comes to visit, might visit someone at their senior residence community, might visit them at home. There might be a court investigator. There might be the guardian ad litem who's actually assigned to the potential conservatee so that the guardian ad litem and the conservatee have a one-on-one.
Is that like a social worker?
No, it's an attorney.
Oh, it's an attorney.
It's an attorney assigned by the court who reports to the court. So we trust Jay. He's a likable fellow. He's well known in the community. God bless him for all the help he gave during the Los Angeles fires and everything. And I certainly wish them both well. And sorry they're an example today, but it's important, right? They're leaders in the community just by going through this. So the guardian ad litem is really there from the court to say, I'm going to assign this professional person who is an officer of the court who's going to look into this, ask questions, find out, have their own report to give to the judge. Because conservatorship is not a light thing. You can't just walk into court and say, hey, this guy's crazy. He should be under conservatorship. We have lots of opinions about people like that, right? But that's not our right to do that to another person, okay? Not if you're taking away someone's right to vote or to enter into contract. So they have to be very careful. And by the way, you'll notice that he started in January and got granted in April. That is very rare. It's more common that it
So
takes
the thing-
several months. Reports have to be submitted. The attorneys have a lot of work to do to make sure that the court gets to see everything the court needs to see to say, okay, I grant the conservatorship of this person because the court is taking away the rights of that person.
Very important to subscribe, to plan for this. If you have a situation that sounds familiar to this story of Jay and Mavis, and you're wondering what to do, we're not going to give legal advice, but we can share our thoughts and point you in the right direction.
Yeah, we really want you to be part of the community because we want everyone to have a functional estate plan. We want everyone to keep their sovereignty. You matter. It really makes a difference that you have prepared for some of the unknowns in life. And life is uncertain, but you can still make your choices and you can decide. Your preferences matter.
And if you do the estate plan now, hopefully you'll never have to be dragged or hauled into court. I mean, that is just really one way to split up a family. Obviously, not having your estate plan done properly or up to date is to go into a conservatorship court.
Yeah, it's
proceeding.
really the court hearing of last resort. You know, no attorney I know would say, "Oh yeah, you want to do a conservatorship instead of an estate plan." I mean, I've never heard anyone say that. So just know if you're very vulnerable, if you're very uncooperative, if you're just not in alignment with life, you also still may be floundering and so on because there's no one to bring a conservatorship for you. So get the estate plan done.
Thank you, Marguerite.
Money management and legacy. Will you be ready for life's decree?